I joined the HOA thinking I'd gain security, only to learn I signed for the wrong property and watched the president resign in chaos. A great number of individuals recommended that I share this story here. This narrative revolves around a piece of property I own but currently lease out. It may seem peculiar, but I doubt I could financially manage living there now it has become somewhat exclusive. This could potentially fit into the category of professional revenge. Perhaps I ought to have posted it here initially. I'm using dollars in this account, as it is the currency that most readers will easily recognize. This account does not take place in the United States, and I have provided an estimated dollar equivalent for the local currency. This will be extremely lengthy. Background: many years ago, my property was part of a vast farm. I purchased it approximately 30 years ago, well after the farm was divided, but before any development occurred nearby. The parcel of land I acquired was adjacent to the back entrance that connected to a dirt road. The pricier plots were situated closer to the paved road at the front. Initially, I bought a considerable portion of the land with intentions of farming, but that plan never materialized. Around 20 years ago, some of the other property owners organized themselves, we will refer to them as the Organized Owners OO, and successfully petitioned to have the area designated as a municipal suburb. The local municipality agreed to install paved roads, water, and electricity if a specific percentage of the properties were developed. A construction company, affiliated with the OO, reached out to landowners who had vacant lots, offering to construct homes for us at a very reasonable price contingent upon obtaining a minimum number of commitments from owners. During this time, one of the OO members approached me with an offer to purchase half of my land. I consented, and the proceeds from that sale, which amounted to approximately 4 times what I paid for the entire parcel of land a decade earlier, along with a small loan from the bank, enabled me to finance the construction of a relatively large and attractive house. I occupied the house for several years, and my mother moved in with me. I had made plans to subdivide the property again in order to build her a house adjacent to mine, but tragically, an undiagnosed tumor claimed her life before construction could even commence. It was diagnosed afterward, but too late to intervene. Shortly after her passing, we vacated the house and began leasing it. Just weeks before we moved out, the OO to whom I had sold the land began discussing the formation of a homeowners association HOA. I was not interested and departed shortly thereafter. Approximately 2 years later, a neighboring OO reached out. By that time, 2 roads accessed the area: the original paved road near the former farmhouse, which connected to a fairly busy main road, and my dirt road back entrance, which had since been paved and connected to a broad, yet lightly trafficked municipal road. The HOA was attempting to close off the old farm road in order to enhance security and reduce through traffic, intending for the road abutting my property to serve as the primary and sole access point to the HOA community. They were pressuring me to join. I refused and was unwavering in my decision. Eventually, they relented but expressed that they wished to install a welcome sign near the road to greet newcomers to the neighborhood, and the only feasible location for it was on the edge of my land. They also proposed constructing a small guard hut and employing a security guard to monitor who came and went from the property, intending to build the hut on my land. We reached an agreement in which they would maintain the lawn and pay the equivalent of around $35 per month in exchange for the land needed. I was pleased with this arrangement, as the property was quite spacious, and it didn't impose additional costs on them since they already employed a full-time gardening service for the HOA. This all transpired over a decade ago. They eventually succeeded in blocking access to the other main road, and the HOA began paying for a security guard to be stationed near my property, in addition to maintaining my lawn and providing sufficient funds for takeout meals for my family each month. Members of the HOA periodically contacted me, trying to persuade me to join, but I remained disinterested. My property has been leased to the same tenant for all these years, and everything has been going well for me. That is until about 3 years ago, when someone frightened my tenant's young daughter by making bizarre noises and firing a gun near her bedroom window 3 or 4 times over the course of about a month. This incident alarmed my tenant, and I surmised it concerned the HOA as well. as both they and my tenant approached me with a proposal if I joined the HOA. They would grant me exemptions from the HOA rules, including the exemption from paying monthly dues. And in addition, they would construct a wall encircling the entire HOA neighborhood, complete with electric fencing and security cameras. They claimed they had wanted to undertake this project for some time, but were unwilling to build the wall on property not belonging to the HOA. Seeing no disadvantages, I agreed. The dishonest dealings, it took slightly more than a year to erect the wall and complete everything, which was fairly expedient. 1 month to the day after everything was finished, my tenant received an HOA warning regarding his dog's barking. He informed the HOA that although the property was within the HOA, it was exempt from the rules. The HOA stated that they had revoked the exemptions and that he now had 30 days to comply. He reached out to me, and I opened some correspondence I had received from the HOA. I had disregarded it, believing I was exempt from the rules and fees. I was in for quite a shock. They had retroactively annulled the exemptions and were asserting the following one: that I owed late fees dating back over a year too, that the easement agreement had been rescinded, and that they were retroactively canceling it a year prior because the HOA contract permitted them to utilize small unused portions of HOA members' land for the common good at no charge. 3. That I needed to reimburse them for the payments they had made for the easement during that time frame. 4. That I owed them fees for the landscaping service maintaining the large lawn. And 5. That I would incur fines for each infraction my tenant failed to rectify. This initiated an expensive process involving lawyers and the court system, ultimately culminating in a judge informing me that most of what the HOA had done was legal. They had the right to revoke the exemptions, but must provide me with 30 days' notice. As I was leaving the courthouse, the neighbor OO, the one who purchased half my land all those years ago, remarked that I was foolish for having declined to join the HOA in its inception, suggesting that I could have become a founding member, whatever that entails. He advised me to thoroughly comprehend any documents I signed in the future. The malicious compliance. The neighbor OO had a valid point. I should have scrutinized the contract more diligently. I also became curious about what it entailed to be a founding member. Spoiler, nothing significant. And so upon my return home, I retrieved the HOA contract I had signed along with all the accompanying documents provided to me and began perusing them. I was determined to exploit every rule I could find a loophole to circumvent. I didn't even get past the first page. While the street address of the property serves practical purposes in identification, the city records assign it a unique property number that must be used in legal documents. When my mother moved in, I had subdivided the remaining property but had not initiated construction yet. When I granted the HOA the easement many years before, it pertained to the parcel I had divided for my mother. The HOA subsequently set up the contract, utilizing the property number from that easement. The next day, the neighbor OO delivered 2 documents for me to sign, one notifying me that my exemptions would terminate in 30 days, and the other announcing that the easement would no longer be required after 30 days. I suspected he was being a bit vindictive since I lived about an hour away from the property, yet he drove out himself. The revenge. Precisely 30 days to the hour following the HOA's notification, I knocked on the neighbor OO's door. Did I mention he was the president of the HOA? And had him sign for 2 documents. The first indicated my intention to construct a house on my HOA property, which bewildered him, and the second informed him that they had 30 days to remove from my property the guard hut, portions of the electric boom, and the sign. He attempted to engage me in conversation, but I ignored him, climbed into my car, and departed. Early the following morning, an attorney from the HOA called to inform me that their belongings would remain on my property because it was in an unused segment of my land. I explained that I planned to build a home there, which would render the land no longer unused. I could hear the condescension as he asserted that constructing a second house out of spite would not be supported by the courts. I hoped he could detect the satisfaction in my voice as I explained that the property in question did not contain a house and was barely large enough to accommodate any dwelling, thus insufficient for any extraneous constructions. I then instructed him to consult the city records regarding the property and return my call. I had trimmed off just enough to remain within legal boundaries while still having room for a small house. They took just under 5 days to respond. Their attorney pointed out that the terms of the easement indicated I couldn't cancel it without their consent, so I emailed him a photo of the document they sent me rescinding the easement. That afternoon, the neighbor OO invited me to lunch, his treat, to discuss the ongoing issue. I declined. 2 days later, he extended another invitation, and once again, I turned him down. Others from the original OO reached out in attempts to converse. Some sounded confrontational, while others appeared sympathetic. I consistently responded with, "No thanks." Eventually, the attorney reached out, inquiring whether we could negotiate some sort of settlement. I asked what he had in mind, and he indicated he was willing to discuss exemptions in return for access to my property. I replied, "No thanks, and please refrain from calling me again." Nearing the conclusion of their 30 days, I received a call from a different attorney. He wanted to negotiate a surrender, his wording, not mine. I agreed to meet him at his office the next day. I had already prepared documents, and the meeting proved simple. I presented him with the documents, which he read through. My new easement proposal. 1. Included all the provisions from the original easement. 2. Changed the phrasing from "mow the lawn" to "bring the property to HOA standards and maintain those standards," as it was now part of the HOA. 3. Would cost them around $500 per month instead of approximately $35. 1. This amount would also increase with inflation. The earlier agreement omitted that clause. 4. Upon cancellation, for any reason, the HOA would owe me a cancellation fee of about $7,500. 5. The contract would automatically terminate 30 days after 1. Any disciplinary actions were taken against me, my tenant, or the property. 2. Any complaints were filed by the HOA against the property. 3. Any legal actions were initiated against the property by any residents within the HOA. 6. That the attorney who had previously offered to negotiate the surrender would serve as the mediator in any disputes between us, at the HOA's expense. And 7. The HOA would cover all my legal expenses should any legal actions arise against me. I intentionally retained some ludicrous stipulations to appear as if I was conceding certain issues, or could be negotiated down when the HOA would inevitably become indignant over the points I actually prioritized. The attorney appeared displeased. He remarked that my proposition seemed unfair, but assured me he would present the HOA president with the details. I reminded him that in 8 days, I would enlist a crew of men armed with sledgehammers and anger management concerns to deal with whatever remained on my property. That evening, I received an irate phone call from the HOA president. He told me he would never approve the new contract. I responded, "Okay." He then insisted that I was charging too much per month and that it should align with the previous contract's rate. I pointed out that when I initially signed the former agreement, the area was in the midst of development, and at least one alternate road was available for entry and exit. Now, my road was the only access point to a fully developed area. He complained that I was compelling them to endorse a document they were disinclined to accept. I reiterated that he was free to refuse to sign it. He lamented about everything conceivable. Ultimately, he stated that I would be hearing from his attorney. The following morning, the surrender lawyer called inquiring if I would be willing to visit their office to sign the contract. I agreed. Upon my arrival that afternoon, I discovered that the surrender lawyer was not an actual lawyer but a paralegal. He handed me the contract and requested my signature. He chuckled when I informed him that I needed to read through it first to ensure no alterations had been made, muttering something that sounded like, "I'm sure you would." I examined the contract. Nothing had changed, not a single thing. The HOA president had signed it, with the surrender paralegal witnessing the signature. I turned to him and asked, "Why did he sign this? It was foolish to do so." The paralegal replied, "I began to tell him that signing it would be unwise, but he instructed me that I wasn't on the clock to think or provide legal counsel, and to be quiet. So I complied." I inquired, "Do you realize what he has signed?" He looked at me and nodded. He said, "I asked him if I should consult one of the lawyers before presenting it to you, and he responded that we had already charged enough for this and insisted that he would sign it and deal with the repercussions afterward once their easement was secured." This ordeal unfolded about a year and a half ago. It took 6 months for the HOA to comprehend the predicament they had placed themselves in. They considered suing me, but their attorneys explained that winning was implausible. Even if the court ruled in their favor, the only outcome would be the voiding of the easement contract, and they doubted the court would side with them. The attorneys emphasized one critical point: the HOA could not tolerate the clause stating, "The HOA pays my legal expenses if legal action was pursued against me." Since it did not delineate who could take legal action against me as worded, the HOA would be obligated to cover my legal fees for actions taken against me by anyone. They opined that the courts would likely refuse to enforce that clause, given that the context of the agreement pertained solely to the HOA, and I affirmed my readiness to discover the outcome, as the HOA would, without a doubt, be the ones initiating action against me should they challenge it. I ultimately agreed to sign an amendment to the contract indicating that the neighbor HOA president would be personally responsible for all my legal fees unless he held no position at all within the HOA, and that the HOA would cover all legal fees if the HOA pursued action against me. He resigned from the HOA following that meeting. I courteously advised him in front of the group that he ought to avoid signing documents without first comprehending their implications. He did not appear pleased. During mediation, the delight on the lawyers' faces when they realized their paralegal would be overseeing the mediation was unforgettable. It emerged that without the capacity to manage access to the HOA neighborhood via the security barrier, partially situated on my property, the HOA had transformed into a gated community. Several years prior, the HOA would be in breach of their own regulations and face dissolution. I also discovered, which should have been evident, that all the security cameras were wired, leading back to the guardhouse guard hut. In essence, it was my way or the termination of the HOA. That initial mediation was quite amusing. My paralegal appeared rather downcast as we gathered, and he initiated the proceedings. I suspected he had been instructed to work against me, so I took the lead. I reminded everyone that I had consented to allow the paralegal to mediate, but I had not agreed to engage in arbitration of any form. If I felt the proceedings were unjust, I would leave, and they could proceed to sue if they chose. The paralegal perked up, and things started to progress quite favorably. I am writing this after returning from the latest mediation. I constructed a paddling pool for the neighborhood dogs. I built it myself. I excavated a hole, filled it with stone, and applied a concrete finish. It was my first project, and I must say it looked quite unappealing. The HOA called for a mediation meeting, their current approach, instead of pursuing official action. I had declined their mediation requests in the past, during which they conveyed, as politely as possible, that the paddling pool was an eyesore right at the entrance of the HOA. I requested they compile a list of necessary repairs and how those fixes should be executed, and that they deliver it to me at the next meeting. The list was extensive and essentially dictated that the pool needed to be reconstructed from scratch. I inquired if there existed any means to minimize the expenses for the work required to bring it up to HOA standards, and they confirmed there was no possibility for cost reduction. I thanked them, pulled out a copy of the contract where they had agreed to bring the property to HOA standards, which I had highlighted, and handed it over along with the list. I informed them that the HOA typically preferred these matters to be resolved within 30 days. They began to argue until the mediator reminded them that they could not compel me to comply without risking the termination of the easement. I should mention at this point that their attorneys generally no longer attend these meetings. They assured me they would take care of it. I also gleaned some intriguing information about the neighbor during today's mediation 1. I discovered that neighbor had sold his property approximately 3 months ago and is reportedly relocating to Australia. 2. I also learned that the HOA had successfully sued him for a substantial sum due to financial losses incurred from his mismanagement stemming from his vendetta against me. 3. Lastly, I discovered that he held a personal vendetta against me, and I have no idea what I did to provoke it. I am uncertain whether I will continue to clash with the HOA. I believe I am nearing the point of breaking them, with the only factor preventing them from terminating the contract being the significant financial repercussions such a move would entail. Much will depend on how they treat my tenants and me going forward. Additionally, I do appreciate the monthly payments, so I am motivated to maintain a cordial relationship. Summary. The HOA president entices me to join under false pretenses that are later upheld in court, only for him to discover that he had signed the wrong property, literally, and must resign after leading the HOA into an incredibly costly situation from which they cannot extricate themselves. Thank you, everyone. When I initially posted this on malicious compliance, I felt like I could soar and was eager to share. Now that the excitement has faded, I feel as if I have been kicked by a mule. I thought some might enjoy the tale, but also worried it was too lengthy for the majority. It seems I may have misjudged. There have been countless comments and messages that I simply cannot keep up with. I sincerely appreciate each and every one of you.